Good afternoon, everyone. My name is Alexis Alvarez. I'm the Director of Statewide Training at Florida Legal Services. I'm very excited to be here today with you, learning in community about an important topic that we really don't get to talk about that much as legal aid practitioners, business entities for legal aid lawyers. And, I'll start off with a little bit of an anecdote. I took the Florida bar in 2015. And back then, or I don't know if it's still the case, but you had the possibility of business entities showing up on your bar exam or trusts and estates showing up on your bar exam. And I was one of those people that said, please don't let it be business entities. And it was business entities. And I passed, so don't worry, everyone. But I bring that up to say how excited I am to touch this subject again that I have not touched since the Florida bar. So thank you all for being here. And more importantly, thank you so much to our speaker who I'm going to introduce for being here and teaching us about this subject that we really wouldn't have the opportunity to learn about without him. So without further ado, I do want to introduce Joseph Barry Schimmel. He's shareholder in Cohen, Chase, Hoffman, and Schimmel, PA, board certified in taxation by the Florida Bar, fellow of the American College of Tax Counsel, and an adjunct professor at the University of Miami School of Law, teaching taxation and business entities. Before I turn it over to Joseph, I just want to mention this is approved for CLE credit. I will announce that CLE code at the end of the presentation. And also this is being recorded and you will receive a copy of the recording along with that CLE code in an email from me within 24 hours of this event. So without further ado, not to make anybody wait or take up airtime with the boring stuff, I'm going to turn it over to Joseph. Joseph, thank you so much for being here to teach us today.
It's my pleasure, Alexis. Thank you for having me. Let's try to get you'll tell me if I did it wrong this time?
I sure will. Looks great.
Okay, good. So welcome everyone. I actually teach taxation of business entities at UM, but that kind of forces me to know everything about business entities and to kind of give people refreshers at the beginning of the semester, because it's hard to talk about tax if you don't understand the business entities themselves. So what we intend to cover, and I'll see if I remember all of these later, common types of business entities under state law. Really the only common types are corporations and limited liability companies, and then the non-entity sole proprietorships. We're going to talk about the basic aspects of business entities, restrictions on ownership and transferability. How do you actually transfer ownership? This is something that we see coming from divorce attorneys way too often, not just with business entities, but with everything. The failure to actually get assets transferred once there's been an agreement on who gets what. And then I'll say a little bit about valuation of entities. I think there's some way of putting questions into the chat. I haven't figured out where the chat is, and I will almost certainly not be looking at it until we get to the end. So if you have questions and you can figure out how to put them in, then go ahead and do it. And I guess at the end, Alexis will help me figure out what they are.
Thank you, Joseph. I forgot that piece of housekeeping announcements. Yes, drop them in the chat, the Q&A. I'll read them out loud at the end.
So what aren't we doing? Well, we're not talking about tax. That's going to be the next session or two, I think. And this is not going to be about how to set up business entities for your clients. If you already set up business entities, then you're not going to learn anything new in an hour. And if you don't already set up business entities, you are not going to learn nearly enough in an hour. So this is really about dealing with entities that are already in existence and what you're going to do with them. So common types of business entities. Let's first talk about the importance of state law, because most business entities are established under state law. A sole proprietorship is not, and technically a general partnership is not. But most businesses other than sole proprietorships are established under state law. And in Florida, those business entities are usually going to be Florida entities. If if you studied business entities for the bar, maybe you learned about Delaware corporations, but there's really no reason for anyone with a small business, either one owner or just a few owners in Florida, to be using Delaware companies or Nevada companies. And if they are, I would personally immediately be suspicious that that there was more going on, or they wouldn't need to use it and spend the extra money. So according to one study of small businesses, half of small businesses are operated through corporations and more than a third through LLCs. According to that study, less than a sixth of businesses were sole proprietorships. But although I found that study in lots of places on Google, I'm not sure that it's legit, because I looked at I'm a statistics junkie. And so I always check and see other sources. The IRS says that of business entities that file tax returns, sole proprietorships, which for tax purpose would include single member LLCs, sole proprietorships file 70 to 75% of all business entity returns. And that number has been, I was surprised, pretty constant for the last 40 years. So that's 70 to 75%. We call that most businesses that file returns are sole proprietorships. And so what are we talking about? Anything from a lemonade stand up, self-employed, Uber drivers, other gig economy people. Basically, if you're not getting a W-2 and you have not set up a formal business entity with the state, you are probably a sole proprietorship. Just how frequently are they in Florida? Because those were both national statistics. Last year, according to the Secretary of State, 80% of business entities that were formed were limited liability companies, and 14% were corporations. And that's close enough to 100% for me. Of total active entities, 2/3 are limited liability companies and another quarter are Florida corporations. So really, for this presentation, not talking about partnerships at all. Some states have other unincorporated businesses like business trusts, but we don't have those here. So like I said, it's all going to be LLCs, corporations, and sole proprietorships today. State law is important because, as I said, most business entities are established under state law. The rights of the owners are determined under state business law. The rights of creditors are generally state law issues. And in a multi-owner entity, the ability to transfer is determined under state business laws. Why do people set up entities instead of just using a sole proprietorship? I mean, obviously, if you have more than one owner, you're going to have some kind of entity, even if it's only a general partnership. But even individuals, the otherwise self-employed, are usually setting or frequently setting up an entity for their business. So why do we have entities? Well, these are kind of the four main reasons, all of which we can talk about. We will talk about transferability, perpetual existence, centralized management, limited liability. What we mean by transferability, in a sole proprietorship, the proprietor, the owner, the human, I'll call them, the human owns everything. They own the contracts, they own customer relationships, they own the inventory. There's no easy way to sell that. Okay, all the contracts are with the individual. So if they want to sell the business, if in a divorce, they want to transfer the business from one spouse to the other, there's no easy way to do it. There's no easy way to sell it or transfer it. With a limited liability company or with a corporation, the entity owns the assets, the entity has the relationships, the entity has the contracts, and it just takes a single piece of paper to transfer the ownership. Also, if you have a sole proprietorship, the human is the proprietor. The human is the business, which means if the human dies, the business is gone. There's nothing to transfer. If there was I mean, the assets are still there, but the business really doesn't exist. If there was an employer identification number, the tax number, that's gone because that was associated with the owner. And contracts may disappear. Perpetual existence, again, humans die. And so the business disappears. Traditionally, partnerships and limited liability companies also had a limited term. They couldn't be in existence forever, but now basically it is only sole proprietorships that don't have perpetual existence. And centralized management is the idea that there isn't one person in charge of everything. When we have even a single member limited liability company, that member does not have to be the manager, right? In a sole proprietorship, who signs contracts? Only the owner, because the owner is all there is. The owner could have some kind of agency agreement or power of attorney to give someone else the right to sign contracts, but they would be acting on behalf of the individual, not on behalf of the business. With a limited liability company, we usually have the owners are, we call them members, and the managers, the people running the business, we call the managers, and they don't have to be the same people. In a corporation, we have directors. Well, the owners are the shareholders. The shareholders, they just have an ownership position. They cannot, as owners, direct the business of the company. Corporations have to have boards of directors, at least one director, and they have to have officers, at least one officer. And limited liability, one of the best reasons that people use entities is to provide limited liability, which when we say it, we initially mean that if the entity, if the business itself has a liability, particularly a contract liability, but sometimes a tort liability as well, that the owners are not personally liable for what happens in the business. And that's important if you're going to end up owning a business in a divorce. You want to make sure that you are going to end up owning an asset and not owning a liability. You don't want to be personally liable for problems in the business. And we'll talk a little more about that subject later. So sole proprietorships, unlimited liability. There is no central management. There's really no management at all, and they're difficult to transfer. Corporations, they have limited liability. Generally the only time a shareholder is going to be liable is if they personally guarantee a liability of a corporation, or if they personally are particularly responsible for a liability. Corporations have that centralized management. They have officers and directors. It's easy to transfer ownership of a corporation. Corporations are supposed to have stock certificates, and stock certificates get transferred just by, it can be as simple as just signing the back of the stock certificate and handing it to someone else. Corporate ownership is represented by shares. I should have posted a little picture of a stock certificate. Not everybody issues them. I find the physical existence of stock certificates to be useful, just in case someone comes in later and questions who owns this corporation. Does the spouse really own the corporation, or is it kind of family owned? I have lots of clients come into my office where it's dad. They start off with, this is dad's company, but once I've asked a few questions, it's, well, Dad doesn't really own the company. Dad just runs it. Dad transferred the shares to me and my siblings. Or, vice versa. Dad really owns the company, even though I'm doing all the work. And if you're trying to divide up assets in a divorce, you really have to start with, let's see the stock certificates. Let's see who really owns the company. And some, depending to some extent on the tax situation, there really may be a lot of fluidity in who owns the company, meaning the spouse that you're dealing with has always said they own the business, but as soon as you try to reach the business in the divorce, they find those stock certificates that have somebody else's name on them. A ownership interest in a corporation, what does a stock certificate represent? It represents really three different, we'll call them interests or bundle. In the bundle of sticks, they represent three sticks. If you remember that analogy from law school. So they are the right to vote, voting rights. Not all stock has voting rights. There can be non-voting shares, but shares either come with a right to vote or they don't. The right to receive distributions on an ongoing basis from the corporation. A corporation is supposed to, it runs a business, it pays its expenses, and if there's a profit, the corporation distributes the profit to the shareholders. And so each share represents the right to a share. Funny how that works, a share of the distributions, a share of the profits. And then on liquidation, if the corporation someday goes out of business and is being, the business is wrapped up and whatever assets are left are being liquidated, not just as ongoing distributions, but corporation shares also may represent a right to distributions and liquidation. Limited liability companies are, we'll say, relatively new, since general partnerships have been around for hundreds of years, probably thousands of years, and corporations have been around since, I guess, the British and the Dutch started colonizing the rest of the world. We've had corporations, but limited liability companies, we've only had since the 70s or 80s. I guess the 70s in Wyoming. Florida was the second state to have limited liability companies, and that was in, I think, 1986. Limited liability companies were designed to be a kind of flexible combination of corporations and partnerships. Limited liability companies do come with limited liability. That's why that's the kind of the first words in there. And that was really the first innovation of LLCs, is that they mostly looked like partnerships, but provided the opportunity for limited liability. Members may contract, sign a contract for liability, and for tax purposes, there may be a reason that a member in a limited liability company would agree to be responsible for some liabilities of the LLC. But as a kind of default matter, LLCs, the members, the owners, don't have any personal liability. Usually, and certainly our preference, or my preference when we're setting up LLCs, is that the LLC will be manager managed. There are generally rights, that some management or approval rights that the members keep in an LLC. And those retained rights are usually more significant than they are in a corporation. In a corporation, almost the only right that the voting right that a shareholder has is the right to pick the directors. A member of an LLC usually has a lot more rights. There are lots of decisions of the managers of an LLC that a member may keep the right to veto. And that's just as true for a multi-member LLC as it is for a single member LLC. And just to emphasize, conversely, in a single member LLC, we think it's just as important to have managers who they may or may not be the member, but when someone is signing contracts on behalf of the LLC, that they be signing as a manager. When someone is signing as a member, I think there's more risk that the person that they're dealing with thinks that that member is going to be personally liable for whatever it is they're signing. And of course, personal liability is the main thing we're trying to avoid with an LLC. In an LLC, the member's interest, the membership interest, that's actually a term we don't even use anymore under the statute, but a member's interest really consists of the same things that it consists of with a corporation. A member has an economic right. The economic interests are what we call the transferable interests, and then the voting interest is what we call the membership interest. And that voting interest, that right to be a member, that's something that is not usually as easily transferred, especially if we have more than one member. And we're more likely to have transfer restrictions in a limited liability company than we do in a corporation. So how do we form these, and what else do we have to file for these different kinds of, I said for each company, I meant for each entity. There's, I guess, my mistake number one with my slides. If I circulate these, I'll fix that. So filings with the state of Florida, a sole proprietorship is not formed by filing anything with the state of Florida, but sole proprietorships frequently use fictitious names. If you have a business, an unincorporated business, you still may want people to write checks not to your personal name, but to the name of your business. You have a storefront, you want a sign on the storefront that's not just your name, and that's the purpose of fictitious names. So those have to be registered with the state of Florida. They're not the same as trademarks. To some extent, they act like trademarks. And those registrations are generally good for 5 years and then have to be renewed. Corporations, they are created by filing articles of incorporation with the state of Florida. Corporations generally have to file an annual report. Not generally, corporations have to file an annual report. So they cannot continue to be corporations in good standing if they don't annually file a piece of paper and send in some money to the state of Florida. Limited liability companies are formed by filing articles of organization, and those articles look a lot like articles of incorporation. And then LLCs also have to file an annual report and pay an annual fee with the state of Florida. Whether you're a sole proprietor, a corporation, or an LLC, if you are in business, generally you're having to get business licenses from the county and or the city where you're operating. Corporations have other documents that aren't filed with the state. Bylaws are basically every corporation should have a bylaw or should have a set of bylaws. Bylaws deal with corporate governance, electing boards of directors, appointing officers, having shareholder meetings so that the shareholders can do basically the one thing they do, which is vote on directors. Corporations may also have shareholder agreements, and those govern the relationship among the shareholders. The corporation may be a partner to the shareholders agreement, but really, for the most part, the corporation's job under a shareholders agreement is to make sure that the shareholders aren't violating the agreement. Shareholder agreement will typically, well, it may cover management, it may cover groups of voting for directors, but usually it's going to have things like restrictions on transfer. And so we need the corporation to be a party, because when you want to transfer, when you want to transfer your shares, you're going to do that through the corporation. It's the corporation that keeps track of who the shareholders are. Limited liability companies have operating agreements. At least in Florida, that's what we call them. And an operating agreement is really a combination of bylaws and shareholders agreements, in that the LLC governs management. It governs how we elect managers, how managers vote. An LLC can have officers, in which case the operating agreement would usually talk about the officers. And operating agreements also include the shareholders agreement types of restrictions. So why are we using shareholders agreements and operating agreements? As I said, centralized management. We may use them to deal with capital contributions. Being an owner in a corporation or an LLC, at least when you first set it up, one of the things you're going to do when you become a shareholder or a member is you're going to agree to make capital contributions. You're going to agree to put money into the entity, and that usually the shareholders agreement or operating agreement, sometimes a separate contribution agreement, is going to spell out what the owner's responsibility is to put money in. Turning the slide would help. The agreements may, they may specify distributions, as you'll hear, I guess, when the next panel goes in a few weeks. Some business entities, even though all the business takes place in an entity, the owners are responsible for paying taxes on the income. So if we don't have a shareholders agreement or operating agreement that requires distribution, then becoming an owner may be may just mean a liability in terms of you have to pay taxes on money you don't get. And so, you know, if you're representing spouses, a spouse in a divorce, you want to make sure that that your client is going to end up with a company that is cash positive, and if it's not cash positive, that at least it's not cash negative, that at least there are not ongoing capital contribution requirements, that there are not what we'll call phantom income, income that you're not getting to enjoy, but you're getting to pay tax on. These agreements also generally contain the restrictions on transferability. Okay, I mean, in a corporation, the default rule is that shares are transferable. You can transfer them subject to, you know, securities laws. You can transfer shares at any time. And so a shareholders agreement would put limits on those transfers. They may include buy-sell rights, which is the right of the company or the other shareholder or LLC members to purchase one owner's interest in the case of, maybe in the case of retirement, in the case of disability, could be in the case of divorce. In a divorce, you may have one of the spouses may really own stock, may really own an LLC interest, but there may be an agreement that says in the case of a divorce, that owner has to sell their interest. And it can say that they have to sell that interest, that those shares or LLC interest, that they have to sell it at a discount. So, you know, that's something that you need to keep in mind, and you need to find out if there are shareholders agreements or operating agreements. You know, one of the things you need to do towards the beginning of the divorce is get copies of those agreements, see what they say. There may be restrictions on transferability that are very specific. Like, you can transfer ownership to family members, but not to spouses. There may be similarly employment contracts that also limit transferability. maybe not directly, but there are plenty of situations where, as part of becoming an employee in a business, you get stock. You may not be able to transfer that stock to anyone, not to a spouse, but to anyone, because that ownership interest is tied to your employment. And there may be a requirement that if you stop working, if your employment terminates for any reason, that you have to sell back the stock or the membership interest, and the price may be basically zero. So so again, that's going to significantly limit the value of stock to the spouse who's not the employee. In a corporation, restrictions on transfer are generally valid unless the statute says unless they are manifestly unreasonable. You can look at section 607.0627 for permitted restrictions. Limited liability companies don't have that manifestly unreasonable limit. In an LLC, the restrictions on transfer can be as manifestly unreasonable as the members like. And the reason for that is that LLCs really were started from partnerships. And one of the basic ideas of a partnership is you get to pick your partner. Other partners don't get the right to swap in and out. And so in this case, LLCs are basically the same that way. Some other state law issues that we look at in LLCs, and I'm looking at the clock thinking I don't want to spend too much more time on these. Limited liability means runs two different ways. There is protecting the owner from the liability for the entity's debts. We call it veil piercing when we make the owners liable, but sometimes just as important as what we'll call reverse veil piercing, preventing an owner's creditors from being able to reach the assets of a company. So this would be important if you have one spouse that owns an interest, but not 100% of the interest in an entity, in an LLC. That LLC may have lots and lots of assets, but not be real good on making distributions. When your spouse gets the interest in the LLC, it does not get any right to distributions from the LLC. And even if they're not going to get ownership, if one spouse is just going to get like a promise to pay or a right to alimony from the other spouse, but the other spouse isn't making payments, generally you're not going to be able to reach the assets of that LLC to compel distributions. In a multi-member LLC, there is no reverse veil piercing. The best you can get is a charging order, which is like a garnishment. And you can read about those in Florida Statute 605.0503. In a single member LLC, you can pierce the corporation to reach assets somewhat if you can show the court that there's no other way to get distributions from a limited liability company. But if we're talking about ways of reaching another spouse's assets that they own jointly with their family, it's going to be very difficult when they own their assets in an LLC. It's much easier in a corporation because generally a court can allow the foreclosure and forced sale of shares of stock, but cannot do that for a multi-member limited liability company. We have anonymity in entities that we can't really have in a sole proprietorship, meaning there is no public registry of the owners of corporations. There's no public registry of the owners, the members of LLCs. Access to records. A member of an LLC or a shareholder of a corporation does have the right to access records of the company. And if you're in litigation with a spouse, you should be able to exercise the spouse's right to records for LLCs and corporations. I've got the statutes there. Why would we want records? You want to find out more information about the value of the company. The corporate records may help you find hidden assets. They may help you find assets that were improperly transferred from the corporation. You can get information about accounts that are owned by the corporation. You may find out that that there are employees on the books of the company that aren't real employees. They may be, significant others. They may be related to the reason for the divorce. And there could be some people may be inflating the apparent or the claimed value of their corporation or LLC, and you need to be able to review the records to make sure that the value is real. Because just as you don't want to give up, you don't want your client to be giving up an interest in a business that is secretly more valuable than you're being told. You don't want them to accept an interest in a business that is secretly less valuable. Sometimes when you get an ownership interest in a company, it comes with tax obligations, and those tax obligations in some cases do pierce the corporate veil. If you've got a business that has not been paying employment taxes and you become an owner, you can become personally liable for those employment taxes. Sales tax liability also, if the company has not been paying its sales tax, it's been understating revenues to the Department of Revenue, and you become an owner of that company, you can be personally liable. So we've, I think, talked some about the transfer restrictions in corporations and limited liability companies. A professional association like your law firm, if you leave legal aid and go into private practice, law firms can only be owned by lawyers, right? Some types of, basically anything that has PA or PLLC after it, a professional corporation or a professional limited liability company, can only be owned by people in that profession. So if you represent one spouse and the other spouse is an attorney, you cannot get ownership of their law firm. Okay, whatever value may be in there, you cannot directly get. You can have agreements that that they'll pay you the value of if they're a personal injury lawyer and they've got work in progress, they've got cases. There may be real value in there, but you're not going to be able to access that value by getting shares of stock in their PA. There are licensed industries that may have transferability restrictions. If one spouse owns a liquor store, they're not going to be able to transfer that liquor store to you because there's a liquor license behind that store, and those liquor licenses are pretty carefully regulated. They're difficult to transfer, and depending on one spouse's criminal background, they may be impossible to transfer. Obviously, there are security laws restrictions. They're not usually going to apply. And these transferability restrictions, whatever they come from, they're important because if the other spouse owns an interest in an entity but has these transfer restrictions, then you may not be able to reach the value. And that may help you determine which spouse is going to end up with which assets. Okay, so you've figured out who's going to own, who's going to own which assets. How do we transfer ownership? Well, we're going to need physical documents of transfer of some kind. If it's a sole proprietorship, you're going to have to find every kind of asset and sell it, bills of sale. You may have to separately assign trademarks or ownership of fictitious names. If it's an interest in a corporation, it's real simple. There's a stock certificate, hopefully, and you're just going to either sign the back of the stock certificate or a separate stock power transferring the ownership. With a limited liability company, sometimes there's a separate certificate, a separate piece of paper, but frequently there is not. You're going to have a document called an assignment, and the transferor is going to have to sign that assignment. That assignment in an LLC, if you want your client to become a member, the assignment generally needs to say that the transferee, that your client has the right to become a member. And if you are only getting part of the membership interest, then your client is usually not going to be able to become a member. Most of the operating agreements that I see or that I draft, the only way that one member gets to transfer the right to be a member is if they stop being a member completely. So once those documents are prepared, they have to be delivered to the entity so that the entity knows there's been a change of ownership. That entity is going to, either the managers of the LLC or the directors or officers of the corporation are going to look at any shareholders agreement or operating agreement and make sure that any transfer was done legally. Depending on the entity, there may be other filing requirements. If it's a member managed limited liability company, then on the company's next annual report, you're going to have to report a change in the members. If your client becomes the member and elects themselves a manager, or becomes the shareholder and makes themselves an officer and director, on the next annual report, or preferably sooner, they're going to tell the Secretary of State about the change so that the world at large is able to look and see that that there's been a change in whoever's in charge of the company or the corporation. Internal Revenue Service usually needs to know, certainly if you had a change of ownership, you were probably going to be changing the address with the Internal Revenue Service. You may need to get a new EIN if what's being transferred is a single member LLC. If you're somehow dealing with a foreign company, it's not uncommon in South Florida to have clients who have interests in family businesses or in real estate that's registered offshore somewhere. When you own an interest in an offshore business, there's a separate form that has to be filed with the Internal Revenue Service, and the penalties are insane if you don't do that. I find even clients who are not really wealthy may have an interest in some land in some Latin American jurisdiction, and the ownership is going to have to be reported to the Internal Revenue Service. I wrote FinCEN, that is, I don't remember what it stands for, but it's a department, it's part of the Department of Treasury. Beginning in 2024, generally speaking, anyone who owns at least 25% of any kind of business entity, not a sole proprietorship, but a corporation or an LLC, certainly, you're going to have to register the ownership with this Treasury Department. Hopefully, it's something that will be possible to do through the state of Florida all at one time, but it's going to have to be done. And again, there are going to be very unpleasant penalties if the FinCEN reporting isn't being done. People, excuse me, refer to the corporate transferability. Nope, that's not what it is. Corporate Transparency Act. That is the law that requires this registration of ownership with FinCEN. And of course, if there are licenses like liquor licenses or Medicare licenses associated with a business, then there may be a requirement to tell the licensing entities. And finally, on some valuation issues, you need why is valuation important? Obviously, if you're dividing up assets, you need to be able to figure out what the assets are. It's pretty easy with real estate. It can be difficult with an operating business. And businesses first are valued in one of three ways: based on the income that they generate, based on the assets that they own, or based on their sales. Lots of businesses are based just on sales. That can be a business of an insurance broker. A lot of professional businesses, CPA practices, dental practices seem to be valued just on gross sales. Most operating businesses end up being valued based on the income that they generate, because that's what you want from a business. You want it to produce income, and it's really more just real estate that you would value based on assets, at least most commonly. Once you find someone, a business valuator or a real estate valuator, to value the business itself, if the spouse doesn't own 100%, then there are generally going to be discounts involved in figuring out the value. And those discounts are because frequently you or the spouse you're getting assets from, you don't have the sole right to control the business. You don't have the ability to sell the assets. That's particularly true if it's a family business where mom and dad started the business and mom and dad have kept control of it, and mom and dad are not going to let any pennies out to any ex-spouses. But even if you're being given a valuation, the other spouse provides an appraisal, and even if you're able to sort out these discounts, which you may not be interested in paying any heed to, a valuation can still be misleading. Lots of businesses have a lot of personal expenses being paid, frequently personal expenses being deducted. That's going to artificially reduce the income taxes that somebody's paying, but they're also going to make the value of the company appear less, because the income is going to appear less than it really is. A lot of times you'll have a business that is being operated at family-owned property, and if mom and dad own the warehouse and the business, the spouse's business is being run out of the warehouse, well, there I guess three possibilities. One is that the rent that's being paid to mom and dad is fair market. I'd say that's the least likely. The other two possibilities are more likely. That is that the rent is too low, which you can bet is not going to remain the case if your client gets the business. And the other possibility is that the rent is way too high, in which case the value that you're being told for the business is going to be too low, because that rent is wrong. Salaries may also be too high or too low. And so an appraiser should be looking at, and you also should try to be looking at, what's really going on in the company, whether it's a corporation or an LLC. And the valuators call it normalizing income. So adjusting all of the expenses and can be revenues going the other way, adjusting them so that they are the appropriate amount. There are sources for all of that. I mean, it's pretty easy to figure out what fair market rent is per square foot. If you can't figure it out yourself, there are plenty of real estate brokers who can tell you, or the Daily Business Review will tell you. Salaries, there are lots of sources, including the US Department of Labor, that will tell you what an average salary is for a particular occupation in a particular business. You can also find out, things like what is an average profit margin for a restaurant, if, for example, and not just restaurants. I've seen lawn businesses that, a business may not be making much money. You may not be able to figure out why, but if you can see that the average business is making 20% profit in lawn service, and you're dealing with a spouse who says, no, I only make 5% in my lawn business. Well, Maybe they're just a really lousy business operator, or maybe there's something else and you have to look harder. Those corporate records are going to help you find these, because you can get a list of employees, see if any of the employees have the same, last name as one spouse, or as a possible paramour, or that maybe they just don't exist and they're being, that there's just fake salary on the books that the owner is taking out and no one is paying tax on. So those are all questions I would ask. And now I guess we'll find out if there are any questions that you want to ask.
Fantastic, Joseph. Thank you so much. Everything that I asked you to put together, you put together and you gave to us, and I really, really appreciate it. For those who are on the webinar, most of you already know from my emails and sending out information about these trainings, but our goal of this training series that started with a webinar on taxation, now a webinar on business entities, and then a final webinar that will be on May 19th, tying it all into dissolution of marriage, is for us to really be able to identify what to do when we approach these issues in a case, what to ask for, how to look at it, and you gave it all to us. So I really, really appreciate it. I did have some questions. You did answer most of them as I was writing them down, believe it or not. Before I go into them, I'm just going to post the CLE credit into the chat for folks that may have to drop off. The CLE code is 2303584, N as in Nancy, and that is approved for one general CLE credit. And I also want to just quickly, before I get into questions, which won't be that many, to drop into the chat that final and next training in the series will be May 19th, and that will be the intersectionality of tax, business entities, and dissolution of marriage for legal aid clients. Register at that link there. While I was giving these announcements, a question did come into the chat. Joseph, it says, anything you are recommending now to help LLCs prepare for, I'm so bad.
FinCEN.
FinCEN, thank you. Reporting. I will remind everyone I'm on parental leave. I have a newborn. I'm happy to be here, but my words escape me sometimes. So what do you say to that, Joseph?
Well, for existing businesses, the filing is going to have to take place in 2024. There's going to be some kind of computer process. You're not going to be doing it on paper. But that's about all I know. That's about all we know. They're still working on it. That's why it's not going to have to happen until 2024. And new businesses will have this requirement, I think, within 20 days of establishing a new business. But again, that's new businesses starting in 2024. So all we're doing is when we set up a new business, we tell the owners, we've basically got a spreadsheet of all the things they need to worry about, all the tax returns they have to know about, all the licensing issues they need to know about. And we've got in there, hey, there's this Corporate Transparency Act that you're going to have to comply with sometime in 2024. Don't forget. We see so many business owners who they don't even remember to file their annual reports, and they get dissolved. So, will they forget to report to FinCEN? They probably will. A small business is usually going to know who their owners are, and the requirement to report is only on, well, it's not just on owners. That's all I mentioned. It's on 25% owners and on anybody who's able to make substantial business decisions. So managers of an LLC and officers and directors of a corporation, but they really ought to know that. It's really just that, stay tuned. How much can a business valuation cost? Is there an average? I don't know about an average, but I'm seeing for an active business, if it's not too complicated a business, probably $7,000 or $8,000. And if it's, we'll say more complicated, could easily be $20,000. when we're getting business valuations, I mean, we're in my office, we're getting them for a specific purpose, which is estate planning. And valuations are going to be, for some reason, they're going to be done a little different in cases of divorce. But you know, I can't tell you why, other than I guess the business appraiser isn't worried about the IRS double checking their work in case of a divorce. So it's just you're just dealing with the other side. But on the other hand, you're much more likely in a divorce to either have competing appraisers, or hopefully, if you can have a little working together, that you can agree on an independent appraiser. But yeah, for a lot of businesses, you could easily be looking at $20,000.
All right. And so a couple of questions that I had are really, and I don't practice in this space, so please forgive me if I'm, you know,
There are no stupid questions.
Thank you, Professor. You know, when somebody is approaching a case, you know, they have the option to go through discovery and, like you said, ask for all of these documents that exist. But there's also this opportunity for folks to do some independent investigation, right? Maybe what they want to do on their own to find what they can before asking for it. When it comes to the things that you mentioned, like the stock certificates, or annual reports for corporations, or even articles of incorporation, is there any way for a practitioner to kind of investigate on their own to try to get those documents without having to formally ask? You know, to kind of be prepared for that formal ask if they're ready to do so.
Well, the articles, anything that's filed with the Secretary of State is going to be publicly available. So the articles of incorporation are, and the articles of organization are. The information that gets filed with FinCEN is not going to be publicly available. I don't think you're going to be able to get it even with a court order. That is supposed to be there just to avoid tax fraud, which, well, not just tax fraud, you know, terrorism funding, drug importation, little things like that. But it's not supposed to be available for just the everyday people. So that's not going to be there. I mean, real tax returns are usually a good source, but yeah, you can't get those from anyone. I mean, we're always looking. I mean, I never believe anything any client tells me, so I'm always looking up their name. When you just Google somebody's name in their city, you wind up with these services. I don't know how the service makes its money, but I know why I like them, because they, you know, have also known, you know, Alexis Alvarez is also known as, and I would easily find out what other names you've used. Usually pops up who else lives in the household. You may think you know who lives in the household because the spouses are living together, but you can be surprised by who else's name pops up.
So, and kind of along the lines of that, another practical question I had is, I recall earlier in the presentation, you mentioned, you know, a client coming up to you saying they own a business, and through questions, you sort of find out that, you know, that business is owned by multiple people. And I kind of thought an interesting or good question would be, you know, what are some questions you can ask in that scenario, or what are the questions that you did ask to get to, you know, that revelation that the client really didn't own what they said they own?
Well, can I see your tax returns? How did you buy it? How did you pay for it? You know, a lot of times it's that. Oh, how'd you pay? That's a nice house. How'd you pay for that house? Oh, it's, you know, like right. First thing they do is they give me their address, and I'm. Especially because, you know, it's so much easier, right, when we're talking, because you don't know whether I'm typing my notes or I'm looking you up on the property appraiser website. So I'm, you know, I'm on Google Maps. I'm looking at, you know, I got Street View. I'm looking at the BMW that the Google truck saw when they drove by. But just, wow, that's a really nice house. And, you know, you don't strike me as the kind of person who owns that kind of house. How'd you pay for it? Oh, my mom, or oh, it really is my mom's, or you I inherited it. Okay, well, that's important too, especially because in a divorce, you may not be able to reach assets that the other person inherited. But yeah, I find that having conversations that go on way too long is the best way to find out information from people, especially from my own clients.
That's a great piece of advice. The only other question that I had, and it's funny because, like I said, I don't practice in this space. So I wrote at the top when we were talking about multiple owners, I put, are there things like clauses to exclude spouses? And I put pre-business prenup. And you talked about that. You talked about these separation, these clauses or these agreements that would exclude or specifically mention if there's a dissolution of marriage, what's going to happen. And
Yep.
my question on that is there something that those are called, or how would you request to try to obtain one of those? Would it be in an article of incorporation? Where would that be? Where would you find that?
Those are going to be in the operating agreement or the shareholders agreement. And the corporation is supposed to have copies of them, and those are supposed to be available for inspection.
Perfect.
In a corporation, any restrictions are required to be on the stock certificate itself. So the stock certificate has to say this is subject to shareholders agreement dated, January 1st, whatever, so that you can tell by looking at the stock certificate. As I said, for LLCs, there's usually not a certificate. If there is one, it's supposed to refer to the written operating agreement that's restricting it.
Awesome. Well, those were all of my questions. I had others, but they were just scratched off. You answered all of them as
Nice.
you went along.
Nice.
And I don't see any more questions in the chat. I
Nope.
am going to put in a little note that, folks, you will all receive a copy of this recording within 24 hours. That email with that recording and the CLE information will come from Zoom. So don't look for my name in your inbox. Look for a Zoom follow-up email. If you don't see it in your inbox, I've put my email in the chat twice. Please feel free to reach out to me directly and I will send it to you directly. And with that being said, Joseph, is there anything that you want to say? I know you've talked enough. Any last minute things that you want to say before we sign off for our Friday?
No, just hope everyone has a great weekend and stay dry.
Yeah, awesome. Well, thank you so much. Thank you for teaching us today. And I hope that you have a fantastic weekend and that everyone else on our Zoom here today does too.
Thanks. Take care. Bye.
Bye.